There we go. For folks who can't join us, I am expecting quite a few more, but I feel like we can get started and people can join as they want. So let's see, actually, I'll go ahead and mute everyone so you can unmute yourself when you want to chime in. Welcome, welcome. Good to see you all. Thanks, folks who are on video. Hey. All right. So welcome to today's webinar around liability and insurance. OMPA had recently brought together a group of industry leaders and stakeholders to talk about the state of the industry and how we're going to protect the infrastructure and what's been built up here. That was largely made up of like OMPA board members and sponsors of OMPA's work. And one of the things that came out of that discussion, and I've heard a few times since, is that people are really craving this information about legal and insurance considerations, particularly as productions start to spin up in this post-COVID world. So here we all are. Thank you for being here. A bit of housekeeping. We are going to host this like a big Zoom meeting because it's fun to see each other. But like I said, if we could just maybe stay on mute, unless you have, a burning desire to chime in. But otherwise, I would say feel free to use the chat window for questions. Questions along the way, like points of clarity that you need, I'll go ahead and moderate and bring those questions in for our presenters. Otherwise, the structure of the event is really, we'll have the legal team present first for like 20 minutes and then have a 20 minutes in Q&A and then have our insurance team present for 20 minutes and then 20 minutes of Q&A. And that'll take us to about 1:30. We did schedule it till 2 o'clock just because I want to make sure you have time to have all your questions answered. But if we are able to stay in that proposed agenda, then we would finish around 1:30. And it doesn't need to be so structured. That's just the idea. I'm sure there will be some free flow between those discussion points too of information. So general structure, but this can also be a little informal as well. I did mention that we will be recording this and sharing it out with people who can't join us today. So let's see, before I get to introductions, I do just want to share some announcements around what OMPA has been working on behind the scenes. You obviously see us continue to push out communications, the jobs emails that continue to add more jobs to, so that's good news. The newsletter and other information as we get it around what's going on in the industry and what information might be relevant to you. So this is still a big part of what we're doing. And we've pivoted to virtual events. Obviously, we're doing this webinar now. Last month, it was a webinar on government assistance programs and how folks can access that. We're doing some regional events. So the beauty of being virtual is getting around the state a little bit more. So our friends down in Southern Oregon host a monthly Cameras and Cocktails for their community, but all are welcome to join. So stay tuned for those invites. It's always the first Wednesday. So the next one will be July 1st. And then we also have the Creators of Color Collaborative that is being held tomorrow. This one as a BIPOC only safe space for them to connect, particularly in light of recent events. So we've been focusing on events and then the advocacy piece of what we do. Thank you everybody who stepped up around the ask for the Portland Film Office. When we needed to hear from you, we did. So that office has been funded for another year, and now we have a work group that's talking about how to come up with a more long-term funding solution for that office. We'll be looking forward to the legislative session and how to protect the incentive bundle and things like that. In between, there's the elections. You saw during the primary season, we collected questionnaires from candidates and shared them out with you, and also hosted a ballot party so that this group can start voting in a block and having an impact on elections and getting folks into positions who are supportive of our industry and our goals. And so we'll be doing that around the general election as well. That's a big focus of ours right now. We posted the protocols. I'm sure you've all seen. I'll put them in the chat window. And I'm sure they'll come up in the conversation here today. So yeah, all that to say, thank you for being members because we rely on your membership. Membership, there is a free option. So if you're not a member or your friends aren't, please tell them to join, although we'd love them to join at the paying amount as well, if you all are capable of that. And I'm going to go OPB this time with our fundraising ask, which is we have a big fundraising goal of $100,000. We're about a third of the way there, but I'm going to break that fundraising goal down into this hour. This hour, we're trying to hit $1,000. So if you find today's information valuable and you want to continue to support the work that we're doing, you can donate here, and I'll report back at the end of the hour or hour and a half how we're tracking to that $1,000 goal. So thank you, OPB, for that inspiration, how to break big goals into smaller pieces. And thank you for helping us reach our goal because you believe in the work that we do and you want us to continue doing it. That's all I have, unless anybody wants to drop a little OMPA related question into the chat. Otherwise, I will head into introductions. Okay, let's see. Is everybody here? I can't see all your faces, but oh, I can see Chris. I hardly recognize you. Chris has a little bit more beard than the last time I saw him. That's funny. Okay, so today I'm really pleased to welcome two big supporters of OMPA and the work that we do, some folks from Davis, Wright Tremaine and ABI Insurance. So Davis, Wright Tremaine is a really well-respected law firm with an office here in Portland that offers a wide range of legal services. And I know this because OMPA regularly taps them and their expertise, and they generously provide it. I've had the pleasure of working closely with Chris Weathers of their media and entertainment team. Chris, can you wave? That's Chris right there. He serves on our government affairs committee, actually. Davis Wright Tremaine is also committed to diversity, equity, and inclusion efforts and have supported our work in that realm. So we're really pleased to have them on our side and to be able to share their incredible expertise with you all. Chris brought two of his fellow team members with him today, Christie, Totten, and Bob Wyman. Can you both wave? I saw Bob, there you go. And Christie, yes, welcome. Thank you for joining us. I'll allow Chris to give them their proper introduction when we get there. But first, let me also welcome Justine of ABI Insurance. There she is. Justine's been a very active member of OMPA. Last year, we held a number of member stakeholder meetings to inform the development of OMPA's strategic plan, and she came to, I think, almost everyone.
Also, maybe one.
Yeah, so really engaged member. We really value her perspective. ABI also sponsored one of our roundtables last year around various business topics relevant to folks in our community. So she's a wealth of knowledge and will have a lot to share with us today. So thank you, Justine, for being here. And then, yeah, let's get started. So legal liability considerations. Let's talk to the fine folks at Davis Wright Tremaine. Chris, would you mind taking it away and introducing your colleagues?
Sure, thanks, Lisa. And thanks for setting up this webinar and inviting us to do this. It's obviously the topic of our time right now. I'm gonna try to share, I put some slides together, and apologies to anyone who's good at video graphics in the meeting. I'm going to share the screen and let's see. Hey, hopefully this works. Does everyone, Lisa, can you see the opening screen? Okay, cool. So yeah, I'll introduce my colleagues real quick, and then we'll jump in. Bob Wyman, he's a partner in our Los Angeles office. He has got, I don't know, over 30 years of experience in all aspects of this industry, motion picture, television. I think he's recently, over the last several years, been working with video game production as well, financing development. He represents lots of the major studios out there and dozens of production companies that are producing for the studios. Both scripted, non-scripted productions. And interestingly, he's also a guest lecturer at UCLA and USC on all aspects of motion picture and television industry, production financing, protection of intellectual property, and other issues. So it's, besides all of that, Bob is also one of my mentors here at the law firm. and I'm really pleased that he's agreed to join us today because he really is a wealth of knowledge to have with us. Christie Totten is from our Portland office. She's another partner here at the law firm. She works in the employment group. Christie is a litigator and litigates in both federal and state court, and then advises employers on just a whole host of matters, including disability accommodations, employment and severance agreements, workplace policies, Oregon pay equity, sick leave, and overtime laws. And she'll get into some of that. As you can imagine, Oregon employment laws will impact a lot of how producers are resuming productions here in Oregon. So, and also I'm pleased that Justine, who I haven't met in person yet, is part of the meeting from ABI Insurance. Insurance is a big issue in our industry. And I am going to be really curious as to some of her insights on what insurance companies are requiring and doing as far as COVID-related coverage. So I'm gonna switch slide here. So with that, let's just jump into it. We don't have a lot of time, and there's just a ton of topics to discuss. And I think what the best approach is just to do some high-level overview, and then as people are viewing and have questions, send them in through the chat for Lisa to present to us in a few minutes here. But I think, starting at the highest of levels, we've all got to look at government, federal, state, county, local government policies out there that may impact the ability for producers to do work in various areas of Oregon, and where it will get into the sort of policies that exist in Oregon or lack thereof in many cases. And there's also lots of industry guidance available. OMPA put up their protocols, which are very thorough. The studios and guilds, AMPTP, put together a white paper with a lot of protocols. The guilds in general have just released some further guidelines. And I just one sort of high level conceptual comment is that with COVID-19, we're talking about a virus that transmits through mucus and saliva, and the name of the game, the sort of common theme that runs through all government guidance and industry related guidelines, is trying to brainstorm all the various situations producers end up in, and then how to avoid the transmission of this virus. So it's in some sense, there's really no true expert out there, because we, except for maybe the high level government virus experts, but there's no true expert. We're all experiencing a pandemic for the first time, and there's a lot of common sense, I think, and just trying to reason through the problem and understanding how this virus is transmitted, and then what we can do to mitigate that. So with that, I'd kind of like to bring in Christie, and I'm hoping that you can just sort of kick this off by talking about the governor's executive orders, how they will impact some of this industry, and what we know right now as far as who can work and what we can do.
Sure, I'm happy to do that. Thanks, and hi everybody. It would be hard not to have some understanding of the phases, and it's in the paper constantly. We're moving to a new phase in this county. We're backtracking to a different phase maybe in this county. I think one starting place to just ground yourself is to go back to Governor Brown's initial executive order from March of 2020. It's Executive Order 20-12, if you Google it. This was the first order that came out, and is still the baseline and still applies. And so it has just a couple really important components I want to mention, because I hear employers sort of forgetting about it as we move forward into new phases. And there are just a couple baseline rules. First of all, I think it's helpful to think about Oregon as opposite to many states. A lot of states closed everything except essential businesses. And Oregon took kind of an opposite approach. The governor said, here are the types of businesses that need to close: bars and arcades and amusement parks, and there's a list in the order. And if you're not in that list, you're not required to shut down your workplace. What you're required to do is a couple things. Number one, you need to have a social distancing policy. So you do need to have a written policy about how those who have to be in the workplace, who can't telecommute, are going to, what the protocol is. Well, I'll back up. So first, you have to facilitate. The employer needs to facilitate telework to the maximum extent possible. So there can be reasons that someone cannot work from home, and those can have to do with job duties. They can have to do with lack of access to telework equipment or network issues. So your starting point is figuring out who can work from home, and if someone cannot work from home and needs to physically come somewhere, to document why that's necessary. And that's going to be pretty obvious in terms of filming or something, right? It's really the same thing as someone who says, well, I produce this product and I need to come into the factory and make it. That's a pretty easy thing to explain. But for certain work at a computer, the first step is to figure out who can telework. And then the second and third steps are, you need to have the social distancing policy for those who can't telework. And you have to have a social distancing officer. That's an employee or officer who is tasked with implementing and enforcing your social distancing policy. So this can technically be anyone, but you do need to make sure that person has the authority, the practical authority to reprimand someone who's not following the rules, that they are someone who's able to document concerns and address them timely and follow up and communicate with folks. So those are the baseline rules that just exist in Oregon. And then as we move into different phases, certain industries have additional rules if they want to open up. But as I think Christie might want to talk about, the film industry is not listed in that executive order. There's no order saying you may not pursue your work.
It's interesting because, the executive order lists, bars, restaurants, barber shops, amusement parks and museums and parks and whatnot. But in effect, there's nothing specifically preventing someone from producing right now. However, provided that if an employee or your crew can telecommute, so for instance, pre and post-production work, then they have to. But if you can shoot at, find a vendor that's open and will let you shoot at their soundstage or what have you, you could do that provided you have the policy in place and the officer. If you're going to shoot at locations, let's take a restaurant, for example, then additional guidelines would have to be followed because there are specific guidelines. So unless, you are in a county where a restaurant is open, where you can go into the facility, then I think you can't film there right now. I also did a survey in preparation for this webinar of various counties. I didn't look up every single one, but I try to focus on, various population centers and cities as well.
Out of the kitchen.
And our state is just silent on this industry for the most part. There's no direct guidelines, which is beneficial in a sense. But you need to, I think, as one of the themes will point out, federal, the CDC, OSHA, state, executive orders, county, these things it's all very fluid. You have to monitor these policies on a regular basis, and in addition, monitor outbreaks, because a lot of what you have to do to implement your policy is just to have good common sense and good judgment. So with that, we can look at the various industry guidelines out there as examples of how producers can develop their policies. Also, what will be interesting is to hear from Justine about what insurance may require. They may want to review your policies, or they may have their own guidelines that they want to see implemented if they're going to cover, if insurance is going to cover COVID.
So Chris,
Yeah.
So related to that point is, well, Oregon itself, might not have specific rules that are relating to motion picture and television. There are a lot of rules that have come down from the guilds of late. And, the major guilds, SAG, WGA, and TPT put together a series of guidelines also. So to the extent that you're involved in a production that has a union or guild requirement to it, then even though Oregon itself might not have rules, their union members are required to follow those rules, and the signatory companies will be required to follow those rules as well. What's kind of most interesting about the rules, besides what you would expect to see, make sure things are clean, everyone wears masks, segregate departments so that they're only dealing with themselves to the extent possible. It seems what's most interesting about those rules is that they basically say these rules are subject to change kind of without notice. We have the right to come in and inspect and figure out what's going on before somebody gets qualified to use one of our SAG actors as an example. SAG needs to review the protocols that you have in place, has to sign off on the protocols in place. SAG has in fact closed down one shoot that had started a few days ago because they didn't think they were properly following the protocols, and they pulled their actors off it, and that shoot is attempting to then refigure out what they're doing wrong, work with SAG, and try to get themselves up and running. There was an article that, Chris and we were all talking about earlier today that Jurassic Park, the film, is going back into production, the next version of it, kind of the first super big motion picture, though it has massive amounts of CGI that can be done on computer, so it's not as hugely complicated as just, big crowd scene kind of films. But still, it's an awful lot of people involved in that kind of film. And they theoretically, it was reported that, they have a COVID line item of basically $5 million just to comply with the COVID requirements from the guilds and the CDC and their local. So, I mean, this is not a small issue. This is an issue that costs, a tremendous amount of money for productions to keep going. And yet at the same time, you have to deal with, guilds who really don't have a lot more expertise than any other individual out there, but still have the right to close you down, which does run some additional risks also.
I think we are finding, and this isn't exact science, but we are finding that, I mean, 5 million is a big chunk, and that's a very large production. But we're expecting a 10 to 15% increase in production costs. And
on a $100 million picture, it's actually a lower percentage than that. But it still seems like an awful lot to comply with the various requirements.
And so, which is a good segue into. As Christie mentioned, you have to have a written policy for your safety guidelines. And what we are seeing here at the firm are, many clients are asking us to draft these policies. Others are asking us to review policies they've drafted. Or in some cases, studios are sending their third-party producer policies for us to take a look at. So I've been the last couple of weeks working around the clock, looking at lots of policies and seeing various ways people are implementing them. And we just sort of thought we would discuss for a moment the sort of materials producers are going to want to develop prior to resuming production. There's obviously the big safety guidelines policy that's going to set forth basically how to approach the ins and outs of production, everything from meals and travel, various departments, general guidelines for crew and talent. As Christie also mentioned, the state requires you have an employee or officer dedicated to implementing and enforcing these policies. And so, part of that is going to be training, regular, daily, like I said, you have to monitor the situation, monitor outbreaks. You're going to have daily or very regular email updates to your cast and crew before they show up, highlighting specific concerns at locations or specific concerns because of various outbreaks as information becomes available. And to sort of kick all that off, I think it's important to note you're going to be bringing in your cast and crew. You're going to be bringing in employees, and it's there's going to be anxiety. There's going to be people out there that aren't going to feel safe at first. You have to learn to trust that these policies are working, hopefully. And so just sort of messaging is part of it. I think it's important to have develop these policies ahead of time, to reach out to folks you're engaging and let them know, share the policies, let them know that there's going to be training, and start that sort of conversation to sort of because common sense is part of it, and then so is just all of our sort of general collective concern for our health and well-being. So I think employers and employees alike share these concerns, and so part of that, part of the messaging is important to develop and implement these. Christie, I was wondering if you could talk just a little bit about in Oregon. I don't know if there's some of the producers in our audience have full-time regular employees at all, if they've had to furlough people or if they've laid people off. Can you just talk a little bit about bringing employees back in, if they've been furloughed or rehiring or just hiring, and any considerations we need to think about under COVID?
Sure, absolutely. So there are a whole host of things to think about, and I think the starting place is to consider what was the last thing that occurred with this employee. Were they furloughed, essentially put on sort of an unpaid leave for a while and have remained your employee, or did you formally lay off or terminate them? Did they get a final paycheck? And if you're in that boat, then you're rehiring them. You might need a new I-9. You might need to do new rehire paperwork. So just because there's a pandemic, it doesn't sort of excuse the general rules that would apply in hiring folks. One of the questions that we hear a lot is about health screenings, and we'll get into that more, but I just want to flag that it's not lawful to ask medical questions or give a health screening before a conditional offer of employment. So you have to at least have offered the job conditionally before you do that. That can get you into legal trouble. The other thing I would say, I guess two other sort of big picture things. One is, this is a really good time to clean up policies, to get someone's acknowledgement on an employee handbook if you didn't have one. You're going to be rolling out a lot of new policies about everything from safety to all kinds of employment issues. And so it's just a good time to kind of come back to square one with folks, make sure you're all on the same page, get everyone kind of on the same page. The other thing I would say, and this is sort of maybe not so much a rehire thing, Chris, as an employment throughout the duration of the employment. This is not a legal issue. Everyone knows. People who are angry or frustrated or confused are not happy people. They're not going to be happy humans. They're not going to be happy employees. They may file a lawsuit against you or call OSHA or something. There's all kinds of reasons. Hopefully everyone's concerned about all those, doing the right thing, avoiding liability, everything else. And so, I mean, my big takeaway in this whole mess would be to listen compassionately to people, listen to their concerns, follow up, not have sort of quick yes and no answers to what companies can and can't do, but to really think through what's possible, what's feasible. And if your employees are asking for something that's not feasible, to take the time to explain it to them and then document it for yourself, you know, which can be as easy as a quick email to self. Spoke with Christie today. She wasn't comfortable with XYZ. I explained that we have A, B, and C in place. Did she have any other concerns? She understands now. And right, and then circling back. Just taking the time to do those steps will, I think, alleviate a lot of trouble in the workplace and will make people feel more comfortable.
And then sort of just sticking with that, Christie, once, you know, if you've made a conditional offer of employment or you've actually engaged the person, and depending on how the production's running, maybe their guidelines say they have to do a self-assessment at home and take temperatures. I've seen some producers requiring that. I've seen others say show up, and while you're still in your car, a trained personnel will come over and take your temperature with like a forehead sensoring thermometer. And but you know, let's say they've got the fever over 100.4, which I think is the magic number that the CDC is using right now, and they have to go home. Can you talk just sort of briefly about potential laws that impact leave of absence, and also what there's this in our industry, shoots are happening fast and furious, and if someone shows up, they've been hired for a job, and the shoot's going to be over within a few days, and obviously you have to stay home longer than that if you've got symptoms, and the offer is withdrawn. Any issues involving those scenarios?
So good questions, and we could do a whole webinar probably on that. So I'll just hit the high level, and then happy to hear any particular questions. I think the two big buckets you're raising are sort of what questions can we ask up front, and then what kind of accommodations or leaves do we have to offer if we find out that there is some sort of health concern. So disability laws do restrict, generally, this is before COVID, they restrict employers from making medical inquiries and conducting medical examinations in various circumstances. And so once someone's your employee, you are allowed to make medical inquiries or take an examination, which would be like a temperature check, only in certain circumstances where it's really consistent with business necessity and it's job related. The CDC and the Department of Labor have said because of the pandemic, the temperature check is okay. So normally you couldn't just take your employee's temperature, but because the government currently says it's okay, it is currently not unlawful under disability law to do it. You can't go asking a bunch of other questions out of curiosity. So you may ask about symptoms, you may ask for the temperature check, and really employers should just follow what the CDC is currently has on its guidelines. That's the safest thing to do if you plan to do health screenings. So that's kind of one bucket. What can I ask? And with that comes obligations to keep health information private, to keep it both the paperwork private, not to sort of announce in front of everyone, whoa, we have a high temperature here, but to properly manage medical information. The second question you had was, well, what about if my employee now tells me my husband has tested positive for COVID, or my temperature is 101, or any other host of issue. I need to take care of my son who has COVID symptoms. This screen just sort of highlights how many particular types of protected leaves of absence can apply in Oregon. Protected means they have to be granted if the employee is entitled to it, and that you can't retaliate against someone for taking it or interfere. So you can't, for example, terminate someone because they took a leave. The first line here, FCRA, that's the Family's First Coronavirus Response Act. It's only in effect this year, unless it gets extended. If you Google FFCRA space DOL, Department of Labor, it should take you straight to a Q&A page, which has 90 some questions right now. And that's probably a good place to start if you're unaware of this law. But this law grants partially paid time off, up to 2 weeks for sick leave, which has to do with sort of COVID quarantine type issues, and up to 10 more weeks or 12 weeks total of partially paid time off to stay home for childcare. So this law applies if you have an employee who comes to you and says, my child's daycare is closed, I need to stay home with them. That should trigger in your head, or a sickness issue, that should trigger in your head that they might be entitled to this protective federal leave, which is brand new, that you may be able to get a tax credit for it. In fact, you will get a tax credit if you're not taking a PPP loan for that. But just if you're unaware of it, Google that acronym and you'll find a whole bunch of questions and answers, and I'm happy to answer more questions. Below that are sort of all the leaves that have already applied. FMLA, if you have at least 50 employees within 75 miles. Oregon Family Leave Act, if you have at least 25 employees in Oregon. Got Oregon Sick Leave Law. If you have 10 employees in Oregon, it's paid. Less than that, it's unpaid. There's a little, if you have a Portland location, there's another little nuance to that, but that law applies to employers here. You have the Americans with Disability Act and our Oregon version of that, which requires accommodation if you have at least 6 employees. You've got workers' comp, and then down at the bottom, you might have a collective bargaining agreement with a union. You might have an employment agreement specific to that employee, telling them they have some paid time off. You may just have policies. So this is just meant to highlight, there's a whole lot of things that could apply to someone who says, I have symptoms, I'm caring for a household member with symptoms, my child's school is closed and I need to stay home to help them with their homework. All those kinds of things can trigger a lot of protections.
And I would just add, you know, if we do, a lot of productions are having cast and crew sign screening policy questionnaires every day. They show up, sort of asks it. They typically list all the CDC symptoms of COVID. Do you have it? Yes or no? Anyone around, you know, anyone you live with or you've been in contact with within 6 feet from have COVID or COVID-like symptoms. These are what the questionnaires generally consist of. Those questionnaires, that information should go to a very limited number of people and in the company. And as Christie pointed out, with that sort of information, you've got to pretty much segregate that info and keep it secure. On top, I have a sign saying my internet cable's unstable. My internet connection's unstable, so apologies. You know, you got to keep that secure on top of your regular keeping people's personal information secure. There's a little added layer of responsibility there with medical information. If you're going to have a third-party vendor, you know, a medical facility actually do COVID testing, you're going to need the employee or crew member or talent sign a release, an authorization to release that information to you. And then you want to think over time, eventually you're going to want to delete that data from your system. You don't want to hang on to it because after it's no longer useful, you want to delete that data. It's data breach is really a question of when, not if, in 2020. Bob, before I move on, just want to know if you wanted to add in anything about, I know that you've been advising many of your clients and preparing documentation for them to share, you know, for them to use with their productions.
So, sure. So a couple of things that I would add on to this. A lot of companies are treating COVID policies very much like how sexual harassment policies started to get treated a few years ago, which is they become sort of attachments to an employment agreement where someone acknowledges that they understand that these are the policies that are in place and what's supposed to happen if that's the case. So when the sexual harassment policies or harassment policies in general started to get incorporated into contracts, they became attachments. People would read it. There would be very specific information in there about, you know, what the company will not tolerate, and what if you observe it, if you feel you've been a subject to it, there's who you call, how you call, you can remain anonymous, and a lot of that has sort of been used as a form to develop into attachments for employment agreements that relate to COVID, which is if you have these symptoms, this is who you call, this is who you tell, we will keep confidential, etc. And it becomes incorporated within the employment agreement itself and is something that usually has a signature line to sign off on. And that's highly, is becoming sort of highly recommended, just so you have something in writing to show that your policies have been made known to them. It's one thing to ask an employee to sign a 45-page company handbook if it was that kind of company. It's something very different to have them read one page of specific COVID policies and acknowledge that. So that's one of the things that, with respect to contracting has become sort of an approach that people are starting to adopt more and more, because it worked very well, in the harassment range.
And we don't have time to get into the weeds of what some of these policies would say, but I would just point out, there are some really good ideas out there. People are thinking very hard about all the scenarios. Once makeup is put on talent, that talent can't really put on a face mask. So there's advice out there to wear the face shields or screens. If you're going to be filming indoors at locations, have it highly, open all the windows, get ventilation going to the extent you can. If you're going to be traveling around in a vehicle together, get larger vehicles, wear your PPE, open the windows. The producers should be supplying the disinfectant materials. I think the CDC points to the EPA with what disinfectants are best. And then, just sort of every department someone's got to be responsible for disinfecting all the various equipment or props or the materials that they're using. There has to be sort of a chain of custody, make sure, once equipment's cleaned, it's sort of labeled and no one touches it except for one person who sort of keeps track, try to minimize sharing things. Oh, go ahead, Bob, sorry.
I'm sorry, I was going to say, and the development of a lot of these policies are, sort of 80% the same across the board, but each, network producer production company has its own questions or twists. Another thing that it's related to this is, for example, the client that's trying to go back into a production on a show for NBC. NBC has asked them to, provide it with a very detailed package on what its programs are, how it's going to do this, what its protocols are, and then it's all internally vetted. Other clients are doing things for, say, Netflix, who has developed their own incredibly detailed descriptions on what it is you're supposed to do, and that's provided to the client. So it's what ends up becoming your COVID policy to some extent has something to do with who you're producing for. If you're an independent production company making your own show, looking to sell it afterwards, then it is up to you to develop what you think is best. But many of the places that people would be producing for are creating their own requirements and or asking for rather detailed packages and lots of information about where it's going to be shot, local information. What we're talking about here in Oregon is obviously very Oregon specific, but in the event you're shooting a documentary in Oregon, but you've got somebody across the state line in California and you need to go shoot an interview there, there may be an entirely different set of rules that you now need to apply, and someone has to have checked all of those elements out. And the networks or buyers are going to be people who are looking specifically to know that you're doing that and want to know the plan ahead of time to do that. And they're going to want to sign off on it before they'll, trigger their funding, basically.
And then I know we're running out of time, but I want to get to and I don't know if it's an elephant in the room. I don't know if we don't want to discuss it. I think we probably do want to discuss it.
I saw a question. We just got a question on this actually. If you saw that pop up, Chris, so good timing.
So yeah, I think this is a huge issue, and it's a tricky issue to some extent. I think I'll share this with my colleagues to weigh in on, but I just sort of high level statements I would make is when it comes to employees, you do not want them to sign a waiver of liability. And I think Christie will talk a little bit about workers' comp insurance, but you want your employees covered under workers' comp. In some sense, it workers' comp caps liability. If you have an employee sign a waiver, it's likely unenforceable. It goes against public policy. You're also essentially having them waive workers' comp insurance related to COVID, and so you're going to open yourself up to an uncapped type of liability potentially, and just sort of if somebody gets COVID, they can prove that they got it from the workplace, from your production. You made them sign this liability waiver, and this thing goes all the way to a jury. If I was an attorney defending that employee, I would have a field day showing the jurors, this document that you made them sign during this time period. On the other hand, if you have an independent contractor, and we need to talk about that just for a moment, like a bona fide independent contractor, they're a service provider, a company themselves, a company, let's say they have their own employees. Sure, have that independent contractor sign a waiver of liability. I would have that independent contractor represent and warrant that they're covering their employees under workers' comp insurance. If you have, if you're doing a documentary and you have interviewees, you can have them sign a waiver. But I'd like to, I know Bob has been running into this lately in his practice, and I'd like him to sort of talk about that. And then just the last point I make before I'll sort of turn this over to my colleagues is, in our industry, as you probably are all aware, some independent contractors are probably really employees and not independent contractors. And so there is risk with, trying to categorize someone as an independent contractor that really is an employee, and then having you really do want to make sure folks that are truly employees and not independent contractors are employees, and you give them all the benefits and protections required under law, and that they're covered under workers' comp. So I think with that, Bob, I think I'd like you to sort of weigh in on this issue of liability waivers and talk about vendors and interviewees and various scenarios that we see.
Right. So, I mean, what Chris stated is the overall policy, which is you just don't want an employee to sign a liability waiver because it violates most laws. You can't waive workers' comp in most places, and it's also too big a risk. On the independent contractors, if it's a true independent contractor, then it's fine, but you run the risk of somebody being miscategorized, and that's sometimes very hard to tell, especially where I'm from in California. An individual is almost always now an employee. It's very hard for someone to be that, an independent contractor. So again, you wouldn't want to run the risk of saying they're an independent contractor, getting them to sign a waiver, and then having the same problem with them being recategorized, and then your employee has signed an illegal waiver under California law, similar to Oregon. On the interviewees, this has been something that we've been dealing with a lot, because one of the first things that go back into production have been, documentary docuseries, because they just take a whole lot less people to make. And so they're easier to start up. I have several clients who've just gone back or are going back into production. And there was a big discussion, at first everyone was saying, well, we want everyone to sign liability waivers, et cetera. It's really important. And, from a legal point of view, yes, it's easy being the lawyer and saying, absolutely, under no circumstances do we want anybody to be interviewed who hasn't signed away hasn't signed a liability waiver. Same thing with respect to, any location you go into, any place we're going into that's a location. We want anybody involved in the location to sign a liability waiver. All of those things would be legal and enforceable, but what you do is you run into some serious production problems. So for example, I have a show that is involved with, it's a true crime show about, bizarre killings in a particular area that seem to happen all the time. So, they sold a show for 6 episodes. They had the 6 episodes set out. All of a sudden, we're now giving interviewees potential liability waivers. And there are generally on these kind of shows, there are 1-2 people who are essential to the show, and that you need to talk to the cop who investigated it, or you need to talk to the prosecutor who brought the case. And you hand a prosecutor, sophisticated lawyer, a liability waiver that says, if anything happens to you, you're going to protect us and indemnify us, and if your family members get sick down the line, you're going to cover those costs, et cetera, not us. You're going to lose the prosecutor. You're just going to, they're going to say, well, no, I'm not going to sign this document as part of, you're asking me to do your interview for your show and you're not paying me anything. I'm not going to waive all my rights. And so what we found out, or what we've been dealing with here, is instead of having scripted out now 6 stories on a 6-story arc, we are now dealing with 10 potential stories, and we're seeing who's responding to the liability waivers, who's willing to do it, and to some extent, we had to get all of the additional stories approved by the network that they were okay with those trade-offs because they had already signed off on the first 6. So, it's sometimes, as I say, very easy being a lawyer saying, yes, go do this, but my job is to facilitate the production for my client to make it so that they can figure out how to produce this and still deliver it. And while a liability waiver is probably the most protective thing you can get, when it's legal and enforceable, it may lead to you being unable to produce your documentary. And if that's the case, that's not a better outcome. In fact, that's a significantly worse outcome. You need to then just weigh the risk. Am I better off doing the production without the liability waiver from this one person, because I got it from 5, but not all 6, and just go ahead and accept the risk in that situation? And those are really important, both, conversations that need to take place between the lawyer, ultimately the insurance company, and the production company and the buyer on, where and who is going to be willing to accept some of these risks to make the shows that people have been wanting to make. But now, because of COVID, has created this overlay of additional risk and cost, and how that gets shared is really, really the question.
And Christie, from a workers' compensation perspective here in Oregon, are we finding that workers' comp will cover COVID claims?
So that's one of the many things I think that's been changing quickly. Early on, we were hearing the carriers say that they weren't expecting to accept very many claims for COVID because of how difficult it is to prove where you got it, right? I mean, maybe you got it at work, but maybe you got it at the grocery store. I think we're starting to hear that the presumption may flip, or may become a little bit easier to show. But from the employer's perspective, it's really not the company's job to decide. I mean, the company can't decide who gets workers' comp and who doesn't. Your obligation is to give the form 801 to the employee when they say, I have this illness, I think I got it at work. You give them the form, you help them fill it out, you submit it, and it's up to the workers' comp carrier to decide what happens from there.
And I'll just make one final note about liability waivers, even the enforceable ones. In Oregon, you can't, if the employer is, or the contracting entity is being grossly negligent, reckless or willful misconduct, those liability waivers won't hold up in Oregon. It's a public policy issue. We have case law that that says intentional, misconduct is not enforceable. So, normal, regular negligence that doesn't rise to the level of gross negligence, those waivers, have a better chance at being enforceable. The courts will kind of go through a series of tests to, they'll look at how unambiguous and conspicuous the language was, what the disparity in the bargaining power between the parties were. Did you offer the waiver as a sort of take it or leave it situation? In other words, was it like a contract of adhesion? And they'll weigh those factors. But just to note, they're not like sort of a foolproof way to prevent liability.
Well,
I think that
to speak to that one last thing, I mean, these are completely untested altogether. I mean, they're being created. No one has brought a claim under them. It's very possible the courts might just decide one day that we're going to throw all of these things out as a matter of public policy. There are a great deal of liability waivers that exist out there, especially in the reality TV game show kind of world, where people were basically signing things that said, you may kill me and then you can sue me because I screwed up your production and not being there till the end. And people would sign that because they wanted to be on a reality TV show so much. And later on, the courts have simply chosen to disregard some of those waivers entirely, just because in that case, super broad. But as a practical matter, that they may say COVID-19 is such an exceptional item that we just don't think it is appropriate for anyone to waive risk related to that. But we won't know that for years down the line. So it's still worth trying it, at least in places where you think you have the possibility of it's standing up, and doing it narrowly, the way Chris said. The broader it is, the more likely it is for a court to say, this just doesn't feel right. And since there's no real precedent one way or the other, have an absolute right to sort of decide to just throw it out if they choose to, even if both parties willingly agreed to it.
And just so you know, if you're not following federal, state government, local guidelines, that'll be evidence of your negligence. And that's what people will be looking for. With that, I know we've totally blown over our time. Lisa, do you want to?
Yeah, I know. So warning, folks.
Want to take it over?
Clock, but so that's not necessarily over, because that's what we have booked in your calendars. But I think obviously this is valuable information. So let's just take a few questions before we pivot over to Justine. The most recent one: what are your thoughts about the talk at the federal level of an idea to protect employers from liability through federal legislation?
Bob, do you want to?
I'm sorry, could you run that again?
Yes. There's talk at the federal level of an idea to protect employers from liability through federal legislation.
Right. So, I mean, there's talk at the federal level realistically about almost, multiple different ways. There's talk about backup insurance plans, which are one of the ways that they're looking to protect the employers. There's there's backup for insurance companies, which I'm sure Justine can speak to better than I am. But the point is that because of the additional liabilities and risks, all of those things are sort of on the table. It's very much like, when COVID first came out, lots of people lost their jobs right away, and they sort of rushed to fill the most obvious initial problem, which is, we need to get some money to these people who have now all lost their jobs and can't, afford their rents and to eat. Once we've gone sort of past that immediate crisis, it's become more and more clear that, the businesses that are then employing these people or employing people in general in order to go back to work, which the government wants them to do, and yet at the same time, you increase the risk substantially by doing that. How do we talk them into doing that without creating a liability or protection program for them, either directly for the companies themselves or by way of backing up insurance companies who are then, going to be more willing, obviously, to write policies to protect folks down the line. And I mean, in my view, it'd be great if it happened, but that's, has more to do with a political view than a legal view, I'm afraid.
David Brain.
I had two questions on here that I could answer pretty briefly. And the first one I really wanted to answer because I know she asked it quite a while ago. The question was way back in the beginning when we talked about the Governor Brown's executive order and having a social distancing officer, someone designated to implement and enforce the policy. And the question was whether that can be a different person every day. So the governor's order says designate it says an employee or officer, which sounds like one. That said, I don't know that it always would have to be one. So for example, if you had 3 work sites, someone who's only at site number 1 really can't see what's going on at 2 and 3. So it wouldn't really make any sense, I think, for that person to be the social distancing officer, because they can't look around and say, you don't have your mask on, put your mask on or you're going to receive a final warning and your employment might be terminated, right? So I don't know that having a person is necessarily required, although that's what the order says. But I think the challenge with having a different person every single day is that you lack that consistency and that training, because ideally you're going to want to show, this person knows what they're looking for. We've trained them on the protocol. They're treating people the same. So there's maybe a little flexibility there, but I wouldn't just sort of change it every day if you don't have to. And the other question that I think is a pretty discrete one is the most recent, which talks about what about if it's a 1 or 2 day shoot? Are you on the hook for the employee's pay if they show up with a fever, for example? So in Oregon, if I'm an hourly employee and I come to work and I have a fever and I'm sent home, then I should be paid for that time that I was there. So if I came in and it took me 20 minutes for that to happen, I should be paid for at least that 20 minutes. You could choose to round up to an hour if you wanted, but you don't have any obligation to pay for the whole 1 or 2 day shoot unless you have a contract that you told that person, I'm paying you for the whole thing. Now, if you have that, then you should follow the contract. And I think that's kind of the end of it. You are certainly allowed to send people home for having the fever. The CDC has made that clear, but if you've agreed to pay them, then you're going to need to pay them.
It's fairly standard in entertainment contracts for freelancers to have a provision that simply allows you to suspend or extend, or terminate in the event of disability. So even if you had a contract that was for the full week shoot or 2 day shoot, if someone came up in sick and you needed to send them home, you probably, if your contract was drafted properly or you had this standard provision for disability, you would not have to pay them by following the contract provision as well.
And Christie, what if, do you have to pay people if they're taking their temperature, doing a self-assessment at home before they come to the job site?
That's another sort of untested area. So if you choose to take people's temperature at work, then we definitely recommend paying for that time. If it's a 15-minute process to get my temperature taken when I get to work, they should be paid for that. If you're requiring them to do it at home, that's currently a gray area. So I think a lot of employers are just choosing to pay it just to err on the side of safety, having the person record that as time worked. But we don't have any clear rule right now saying that you necessarily have to. The other question that comes up there is, do I have to buy thermometers for my employees if I'm requiring them to do self-checks at home? And I've seen employers do all kinds of things there, but maybe one of the most practical is to sort of assume people have a thermometer, but let them know that if they need to purchase one because of your policy, that they can submit a reimbursement for up to $25 or whatever it is. That sort of makes sure you're not just paying everyone some amount for thermometers, but that you don't have an arguable issue there. And I would say, by the way, if in Oregon, if you do require an employee to go to the doctor, for example, go to health screening, the employer has to pay the cost of that if it's not covered by insurance. So for example, if you say, and this is before COVID, if you say, I think you need to go to the doctor and get a doctor's note to prove to me that you don't have to come to work, there are laws that will require the employer to pay the cost of that.
All right, we'll take this last question before pivoting over to Justine. Let's see, small companies, what happens when someone's ill or tests positive or lives with someone who tests positive? Is the business required to close temporarily?
I'll start answering that. If it depends. I don't know if the whole business needs to close, but that person is generally, required to self-isolate or quarantine, and the CDC provides, this will be in most production companies should have this in their policy, compliance with the CDC, which talks about the timing with that self-isolation. So it'll talk about if you're in close proximity with someone who has COVID or COVID symptoms, or the individual themselves has COVID or COVID symptoms. It's usually just kind of taking a look at it real quick. 3 days with no fever. You got to wait 3 days after your last fever, and your symptoms have improved, and 10 days since the symptoms first appeared is from the CDC. And that's, and I think, so I guess it's tough for small companies, right? Because you have the limited sort of staff and crew. With some of the larger productions, the advice is to stagger your crews to the extent possible. So if one member of a crew gets sick and everyone's in close contact with each other, that crew would then go into self-isolation for a certain amount of time to bring on the other. But the smaller productions, I do think it's problematic, right? Because you are only running with a couple people, and yes, that could put you on pause until enough time has passed after the symptoms have subsided.
Yeah, I would think you wouldn't necessarily have to close, but you would be very diligent on making sure that everybody in that office who was in contact or on that production is, maybe tested more than just showing up in the morning, maybe during the day, if had somebody who may have been in contact with it, because you just don't want it to spread more. But one person who got diagnosed and is sent home may not have affected the show itself, but you need to be super diligent in your policies then to make and do that extra cleaning and everything else you need to do, and do the testing and see. And if multiple people do, then you probably do have to shut down.
All right, I think this is a good time to pivot. Now, I think you all are hanging out with us, so maybe if there are more questions at the end, we can come back to you with that. But how about a big, virtual round of applause for all of that information that you shared?
Ooh, applause on mute is really cool.
Thank you so much for sharing your expertise, and I'm sure people have more questions that they're going to come pouring out before the end of this, but let's go ahead and, before we pivot to Justine, I just want to say that this is your membership specialist tuning in. We're halfway through the programming and nearly halfway to our fundraising goal for this hour. So thank you to all those who've contributed already. If you're thinking this is valuable information and I'm going to invest in this organization, know that every dollar makes a difference, 1, 20, 50, and you can do that right here. So I'll report back at the end how close we are. So thank you for everyone who's contributed already. And now let's move over to Justine of ABI. Feel free to take it away. And I think you had some screens you wanted to share as well. So
yeah. We'll see if I can get this thing to work again. Okay, is that up for everybody?
yes.
Awesome. So first of all, I want to say thank you so much to the team at DWT. You guys have done an excellent job at covering a lot of stuff. And really, insurance works in partnership with the legal environment. So having really good legal partners as part of your team is just so invaluable. So thank you guys so much for your time. I mean, I wrote down a ton of notes. So that was great. Yeah. So basically, when we look at this, I want to start kind of how insurance has traditionally looked at contagious disease and pandemic. So just to do a quick stat, kind of where we are today, insurers right now are estimating somewhere between 220 billion to 383 billion per month in business interruption losses due to COVID. And then over 3 million people have been asked or strongly encouraged to stay at home by the CDC. So, you know, when you translate that into what is that doing to our economy and what is that doing to the business insurance environment, obviously this is something we've never seen before. It is very, very major. The majority of claims that the insurance companies are paying out are obviously through the medical health care field. And then right behind that, unfortunately, they are paying out through life insurance for death benefit claims for the people who have passed. And then outside of that, then the claims are kind of being paid across a bunch of different industries and a bunch of different lines of business. So this is probably, you know, again, in terms of scale, it's like taking Katrina and 911 and a couple other things and throwing it all together. And it's really, truly a catastrophic exposure for the insurance companies. And of course, from all of us who are living through this. So going back to what we were talking about with the legal team, insurance contracts are actually somewhat of a voluntary contract between the insurance company and the insured. It is essentially at one point a contract of adhesion. The insurance company didn't ask you guys how they get to draft up their policy, but they do have absolute 100% discretion on whether they want to cover anything or not. So outside of like compulsory laws that there might be federally or at the state level, like you have to have workers' comp insurance, healthcare under the Affordable Care Act, or state minimum auto liability limits, insurance companies don't have to cover anything if they don't want to. They can just pick something and say, we're going to do this. They can choose to do it in one state and not another. So it is absolutely at their discretion. So how do they decide how they're going to write insurance, how they're going to price it, and then what coverages they're going to offer? So they basically look at a lot of large numbers and they try to find a bunch of people with similar risks over a really wide geographic area. And when they can make things get to a point where it's a little predictable and budgetable, that's where you get brand new insurance products. So typically in the past, contagious disease and pandemic have kind of been excluded. They consider the catastrophic potential of it to be like war or nuclear, or they may consider it to be a known hazard like asbestos or lead. So after we had the wide outbreaks of AIDS, SARS, MERS, H1N1, swine flu, Zika virus, Ebola, they just said, we're not touching it with a 10-foot pole. So we've actually had, for the most part, on standard business insurance policies, exclusions for liability and property coverage since the early 2000s. And I know that was a vast shock to most of my restaurant clients, that this particular virus exclusion was there. And we'll kind of get into that a little bit later. If you're trying to look at an insurance policy now and figure out, do I have coverage? The places where we did have coverage before were things for the film and arts and entertainment industry, like special event cancellation policies. It was embedded in cast and crew coverage, of course, workers' compensation, and then also in completion bonds, some hospitality policies for restaurants, hotels, and tourist attractions. And then if you had an annual production policy, there was something called eminent peril or business interruption that you might see on your property or your inland marine policy, and that's the one that covers your gear and equipment. So all of those policies are completely non-standard. So to find out whether you had coverage or not, you pretty much have to read it. But sometimes it's not easily apparent whether it was excluded or not. So they can call it a lot of different things. So it might specifically say there's a COVID-19 or coronavirus exclusion. And most of the companies I know, if they don't have anything specific, they're rushing to add that specific exclusion. It might be called fungi, virus, or bacteria exclusion. It could be a contagious disease exclusion or organic pathogen exclusion, or they'll say we don't cover pollution, and in the definition of pollution, you're going to see a virus or contagious disease exclusion embedded in that definition. So, you know, rather than trying to read your insurance policy, just ask your insurance broker to, with a fine-tooth comb, and ask them if there's any type of coverage available in any way, shape, or form that you can buy. So, you know, one of the questions that was asked earlier kind of gets to this question of, are there claims for business interruption and extra expense? So for an insurance policy to cover a business interruption or loss of income type claim, typically there's been a requirement that there's direct physical damage. So if you can go through and just clean off a surface and now the contamination is gone and everybody can use, you know, the piece of equipment or the premises or the location, insurance companies are saying that that doesn't meet that direct physical damage trigger. And so people haven't been able to get business income reimbursement, and also civil authority, you got shut down because of the governor's mandate. Again, there's not direct physical damage. So unfortunately, none of these loss of income claims for the most part have been covered. I have submitted a ton of them, and every single one of them has been denied by the insurance companies, not only because they don't meet the direct damage trigger, but also every single one of these policies had a very specific virus exclusion. So the policies were very clear and unambiguous that they never ever intended to cover this. The one claim we did have paid was a special event cancellation policy where the organizer of a large event had bought coverage in the event of cancellation. That specifically said it covered for pandemic. So we did have one large claim paid out, but pretty much everything else we've submitted to this point is not going through. So that unfortunately is kind of bad news, but I think a lot of people who maybe have submitted their claims have found out the same thing. So, you know, that's just on loss of income. So we're at this point now where we're trying to figure out, how do we reopen Oregon for productions? How do we get out there and start doing our job and, you know, getting our projects out there? So this has very far-reaching insurance implications, which tie into basically the legal implications and the legal environment. So again, really thankful you guys did such a great job setting me up for this. So I'm not going to read this. If you guys want slides, I can email them to you afterwards. But these are all the types of major claims that we expect people are probably going to be bringing related to coronavirus and COVID-19. So again, some of these claims are already wending their way through state courts in different places. But I really want to go down to this very bottom one where it says failure to warn. This goes back to what we were just discussing. So let's say we can't get a liability waiver signed. One thing I don't want employers to do is I don't want them either verbally or when you're doing a call to say, we're going to have a safe site, you know, we're going to be COVID safe. I would really like them to have legally drafted wording that warns anybody coming on set that even though we're going to use, you know, all reasonable care following CDC guidelines, OSHA, whatever else the guilds are coming up with that we're required to use, or Netflix or whoever, even though we're using all reasonable care and precautions, we can't guarantee you that this is going to be a germ-free environment. And trying to figure out how to do the messaging around, if you step foot on this set, you know, you may get sick, you may become disabled, you may pass the illness on to anyone you come in contact with, including your family members, and everybody could die. And that's not a great way to phrase it, but I would really love to see legally drafted warnings or disclaimers that are part of employment contracts, independent contractor contracts, that tells people what the hazard is. So even if you can't get people to sign off on holding you harmless and paying all your attorney's fees and indemnifying you if they get ill due to COVID-19, even if they won't sign that waiver. I sure would like to see at least us creating some really good messaging around warning people about this, so that, you know, there's no way someone can say, I didn't understand the risk when I came in and started working on this project and stepped on set. So that's actually one of my main questions that I've been getting from my people outside of the liability waivers, is what is going to be a correct way to put that kind of disclaimer or warning together so you can still move forward, but everybody is recognizing the risks. And I think there too, that's when you're going to want to have a pact between, you know, the workers and the people who are running the set, the producers. You know, if we do all these things, we're also going to promise that we're going to have certain types of insurance. So that way it is an actual pact between everybody that we're going to comply with things, we're going to adhere to the guidelines, and then also the production companies say, and we're going to actually get the appropriate insurance for this where it's available. So I would love to see a well-crafted legal document that kind of lays out both sides of it. So that's something that I would really like to see, because I think a lot of these other things, again, where we don't have open communication lines, where people are broke or frustrated, again, that's where lawsuits come from. So we talked a lot previously about, you know, safety standards and standard operating procedures. And again, there's a lot of guidelines that we know I have to adhere to. So really the biggest thing I want to say is, if you do have published protocols or standard operating procedures and you don't follow them, you're automatically at fault. So, you know, that really has major implications if there are compliance issues on set. So now on productions, we're going to have to act just like, you know, building contractors. So if people don't show up on set ready to work with the correct protective equipment, you can't let them on set. Or again, if they violate things by not wearing the protective equipment, you have to kick them off set. You know, I recently had a work comp claim where somebody was supposed to be wearing a ventilator because they were being exposed to organic compounds. So volatile organic compounds, they're scent compounds. The person filed for basically having problems breathing and irritation in the lungs. And one of the things was found out is they weren't wearing their PPE. And of course, that was supposed to prevent the lung irritation. And when asked why they didn't wear the PPE, they said, well, it's because it never felt right and it made it hard for me to breathe. So, you know, I can see this being the exact same scenario on a lot of these sets where if you don't have somebody who's a compliance person that can help people with the protective, you know, the correct fitting for protective equipment, you're going to have compliance issues on set, and that's going to open you up for either lawsuits from other people on the set who now are exposed to this person, or again, you're going to have an issue with kicking them off the set and they're going to say it wasn't fair. So again, we're going to have to be very, very on top of, you know, what are the implications of making sure that we have on-set compliance. And so health and safety is every individual's personal responsibility, but it's even more so the employer's responsibility, and then the people who have perceived authority on set for how things are going to run. So, you know, each one of us has to take this into consideration. So the biggest place I see we're going to start having some difficulties really does stem out of the uncertainty around the workers' compensation. And for a lot of people who maybe aren't familiar with workers' compensation, it's kind of split into two parts. So the first part is workers' compensation. This is the money that goes to the worker for when they got sick or they got hurt, and they have now medical expenses or physical therapy, they lost wages. So the insurance policy pays out basically a bucket of money directly to the worker. The second side of the insurance policy in most states has a place that's called employer's liability. This piece will now pay for all the other things that the worker or their family can sue for outside of these direct injuries or direct expenses. So if somebody is ill or they become permanently partially disabled or they die, the family can actually sue for everything that person used to do that they now can't do anymore. So examples of that are, you know, they can no longer mow the lawn, so you have to pay for a landscaping service. They can no longer drive the kids back and forth to school, so you now have to pay for transport. You know, they perform childcare, they're not there anymore, so now you have to hire out childcare. Loss of consortiums in there. Lifetime anticipated loss of earnings is part of employer's liability. And also families who become sickened through exposure to the infected worker. This now is available for coverage underneath employer's liability. So this is a huge area of risk when you put all of those factors together. And so both employers and workers really, really need to think through how this is functionally going to work. And this is what's going to make things hard, is every single state is approaching this differently. So I'm going to talk about Oregon, since that's the state we're in, but I'm going to talk about 2 other states just to show you what a mess we're kind of in with lack of standardization between state and federal. So Oregon, the state of Oregon Insurance Commissioner's Office has taken the position there are no automatic presumptions for coverage for COVID-19. They are actually leaving it up to the insurance companies to make the coverage determination. So essentially what they're saying is this is going to be a strictly facts-based, claim by claim, case by case determination, where the employee is going to have the burden of proof that they more than likely got infected at their workplace. So it's a whole lot easier if you are a healthcare worker, a first responder, somebody who maybe provides childcare, or a food services person. So that could be, you know, farm to table food service, where you are really in contact with a lot of people. You're considered an essential worker. You can't telecommute. It is more than likely all of these people will have coverage under workers' compensation. But outside of that, there really is no guarantee that you're going to get work comp coverage if you get sick on a film production set. So how is an employee going to prove they got it on set and make it compensable under work comp? So this is the big challenge I see facing everybody right now. So, you know, do you get tested before you hit the site so you have a baseline that says, I don't have it now? And then now we have the protocols where at least you're being monitored for fever and for symptoms while you're on set. So there would be another baseline if something happened while you're on set, but then you probably need to get tested again after you leave set, or monitor for symptoms. If you're clear for 14 days, you probably didn't get it. But then if you get symptoms, then you need to go get tested. And then now it's more likely you got it on set. We see this as being a pretty high bar to try to cross. And again, we also talked about, you know, the problem of, you know, independent contractors versus employees. The state is very much looking at who is an independent contractor. And usually the more negligent or more horrendous a claim is in terms of a workers' compensation claim, the more the state is probably going to push people over into that side of, well, that they were really an employee, not an independent contractor, particularly if it's ambiguous and it was gray. So what we're thinking is, first of all, this is going to put a huge burden on the workers, their own individual health plan, or if you have an association or union health insurance coverage plan, if it's not going to be covered under work comp, all those expenses are going to get shifted over onto these health insurance plans. So that means health insurance rates are going to skyrocket, probably. Smaller association plans might actually blow up. They're going to end up being unsustainable, and even really large plans like the union plans are going to be under increased pressure. So the pressure of these large medical bills or unreimbursed medical expenses might make it more likely that workers or their families are going to try to circumvent the workers' comp system and sue underneath employers' liability or other theories of injury to get outside of that workers' comp system. So again, I'm an insurance person. As a risk management person, I see usually the negative side first, and I try to plan for that. And then if something happens where, you know, we make a decision in public policy where it gets better, I'm like, great, this is wonderful. But right now, as of today, I did a very extensive insurance company survey, including SAFE, who is our voluntary market here for film production, and all the other carriers that do work comp specific to film arts and media and entertainment. This is pretty much where it sits as of this moment. You go down to California, they took the exact opposite stance. So basically, if your employer asked you to come back to work or there was no telecommuting option, you were covered no matter what. So it's like, yay, great for the workers, but what does that mean for employers? So now employers have these horrendously huge potential work comp claims, including deaths on their insurance policies, which drive premium rates up. So the NCCI, which is the National Council for Compensation Insurance, is federally reviewing a rule that says for states that take this kind of stance, they may disregard COVID claims when looking at people's future premiums. So if that happens, you know, like in the state of California, the burden's on the employer to prove the employee didn't get it at work. And then the people who are actually going to take the biggest hit on all these claims then is the insurance companies. So now they don't get to charge premium in the future, and they're going to absorb all the claims now. So we're expecting there's going to be challenges by both employers and insurance companies while this gets figured out. And then in a big surprise, the state of Utah, they have workers' compensation just like Oregon. So the burden of proof is on the employee, but they just recently passed a statute that says you cannot bring a liability claim against an employer for a COVID-19 related illness. So that is super great for employers and the insurance companies, but really detrimental for the workers. I can't imagine going out on a production in Utah unless you personally have infallible personal protective equipment. You know, I don't even know, you know, hazmat suit. You want to be tested before, during, and after the production. You need to have good personal health care, and you better have a large cash reserve. So, you know, particularly back to your point about documentaries, sometimes documentaries jump from state to state, you know, and they may get workers from each of those states rather than taking their own crew with them. And so now you have three completely different workers' compensation and liability environments that you're having to operate in. So from an insurance and risk management standpoint, I would just say, please, please, please talk to both your insurance brokers and agents and your attorneys when you're going into different states, and have them bring you up to date on where does it sit today. Because what I published here is basically only effective as of last night. You know, so this is all really changing on a daily and weekly basis. So cast and crew coverage is for basically that blanket accident, illness, and, you know, death coverage for people who are not employees. So at this point, many of my carriers have just quit offering the coverage altogether. They just won't write it. There's a moratorium. Some of them are saying they'll offer the coverage, but they have a strict COVID-19 exclusion. So all the other normal stuff that they covered beforehand, they still cover, but they're not going to cover coronavirus. I have one insurance company that says they might still offer the coverage for large accounts, but only $5,000 per person and $25,000 total per policy. So that's a couple people with very minor medical bills, but hardly any limit whatsoever. So this is really going to affect a lot of indie productions and productions where you had named actors or essential personnel who are used to having their own protection limits. And this is the thing that we really, really, really have to work on changing before I think a lot of productions can go forward. Because if this coverage is not available here, and we have the big question mark on compensable under workers' compensation, that leaves all this pretty much in the realm of pure business risk. You know, it's not insurable. You know, so the only thing you can do is to try to protect yourself as a business in any way you can, either through legal contracts or through, again, really good protocols on set to try to protect everybody to the best of your ability. We're expecting claims in 3 other areas. The employment practices liability insurance, where they were talking about having signed agreements and your employee handbook and things like that, where people read and sign that I understand the protocols, I'm going to adhere to them. And again, how do you deal with sick leave, vacation, pay time off? And here's my big question that I'd love to put back to you guys, because again, I get this constantly. What about the people who are sent home to quarantine who aren't ill and don't become ill themselves, but now they've been kicked off the job? Are they going to get less wages? You know, and again, that's going to partially go back to contract, but this is a real gray area because now there's no doctor's note. They weren't sick. They were just in that contact tracing chain. Like, you were right next to the person who tested positive. You have to go home for 14 days. How are we going to handle those? But, you know, both from an independent contractor and an employee basis. So this is literally the top question I'm getting right now that I don't have an answer to. Directors and officers liability. So any of you who own your own company, your organization, your company, or you as an individual can be sued if you don't take the steps to put in place the appropriate protocols and procedures. So it's a failure in management or control. So for companies that go out and they end up having a major lawsuit that may or may not be covered by insurance, the next thing that's going to happen is stakeholders and shareholders are going to sue the directors and officers for not having done something right. The other thing we see that might happen is they might get sued for a loss in stock value or in their investment value. So particularly for, you know, arts organizations or, you know, larger studios or equipment rental companies or something, if you don't have directors and officers liability in place yet, you maybe ought to think about getting it. And again, because we do see this is going to be a major uptick in claims coming down the road. And then professional liability is even more key right now. Everybody is now disseminating protocols and procedures. The people who are on set enforcing compliance with PPE and being your COVID person, they now are kind of moving over into what we would call a professional services or consulting or advice type exposure. This is not normally covered under any of your general liability policies. They have a very strict professional exclusion on it. And if you are providing certification, you're doing training classes, you may be viewed as a standard setting organization, like the OMPA just put out wonderful guidelines, but are you now a standards setting organization? You are now going to be held to a higher level of professional liability. So if you forgot to include something or made an error in the way you're providing advice or services, you can be sued under professional liability, and you would probably also be sued under general liability and probably not find coverage under general liability. So I think there's a lot of people who don't currently carry professional liability right now that need to be thinking about it. And again, I know the unions already have it and stuff like that, but again, I know a lot of my arts and cultural organizations, some of them that aren't providing those types of services in the past, now all of a sudden are kind of in this gray area. So we're asking them to please look at seeing if that can't be added as a little module to their existing insurance policies. The best thing you can do right now, because it is so unpredictable, is try to put your company in the position of best defensibility. The best way to do that is contracts. So again, our friends here, they and others can do a great job. We need to lay out really clear expectations and then also lay out a clear exit strategy. So what do you do when things start going sideways? And then for everybody, if you're presented with a contract, doesn't matter if you're a freelancer, independent contractor, employee, employer, your professional services agreement, it really doesn't make good business sense to agree to basically assume a risk or take on a risk yourself where that risk is not underneath your control. So anywhere where you see language that says you're going to cover if something happens, but that's not something that you even get to touch, make sure that you line out all that stuff. So the main place where you're going to see this type of wording in professional services contracts or other places is the force majeure provision. What that does is it says if there are circumstances or something in your environment that is so completely out of your control that nobody could have planned for it, which sometimes are very large disasters, weather, or in this case, COVID-19. It kind of outlines whether you have the right to reschedule, how to resume, whether you're just going to pull the plug, and what happens at that time. So I've seen a lot of different wordings on this. A lot of people are now reworking them to specifically speak to COVID or pandemic or communicable disease. Again, do you want it broadly worded or more narrowly worded? That part I can't answer. I'm not an attorney. I don't know what's going to stand and hold up in court in the various jurisdictions. So we really recommend that you work closely with a qualified entertainment attorney to get the correct structuring of this wording. One note here, and I saw it kind of come up on a question earlier, on the insurance side, you mostly see this force majeure wording in completion bonds. Most Oregon productions are smaller and they don't require completion bonds, but for the ones that do, the force majeure wording is pretty close to what you would see in your professional services contract. Again, it's an exit strategy. But the thing you have to watch out for in the completion bonds is there is a salvage clause or salvage provision. And what that says, and many people don't know the difference between insurance and a bond. So an insurance policy says I pay a little bit of premium, and if something goes wrong, the insurance company is going to make me whole again. A bond says if something goes sideways, we're going to pay a bond claim, but then you, whoever it was that pulled the bond out, or your company, have to actually pay back the dollar amount of that bond claim. So that means you have to have a lot of liquid cash. And any liquid cash you don't have, the insurance companies under this salvage provision have the right to essentially, in many of the completion bonds, seize any asset of the production company. So that could be footage you already have in the can. It can be your intellectual property rights, including whatever you might have licensed to be able to do your production. Again, that could be that you licensed an adaptation from a book or something like that. They can salvage sets, props, and wardrobes. So this salvage provision is something to really watch out for in completion bonds right now, how it's written. The best example of this, if you kind of need to get some grounding how this could work, is to watch the Terry Gilliam film Lost in La Mancha. I don't know how many of you guys have seen that, but it is just a train wreck from start to finish of everything that could possibly go wrong in a production. I mean, it's like biblical. The only thing that didn't happen was locusts. So this is a great example of the force majeure and salvage provisions, and how to write force majeure in your contracts so that you know, you do have an exit strategy and hopefully can hang on to some stuff. And in terms of best defensibility, again, if you're following all the OSHA and CDC guidelines and any protocols that are particular to your profession and your specific job duty, if you're in the best of class, when compared to others who are in your same position doing your same duties, you're going to have way better defensibility if there's a claim or a lawsuit.
Hey, Justine, I just want to chime in. I'm keeping an eye on the time, and I don't know how many more slides you have. We have about 3 questions that we'll want answered. So is this one of your last slides, and then we'll turn to questions, or?
Yeah, and basically I have like 2 more.
Okay.
So this is one where, okay, so how do we protect our intellectual property and our assets? So this is one of the biggest things from a risk management standpoint that we're wanting people to really look at is to look at your corporate structure. You may want to create one corporate entity that holds all of your assets. So if you own buildings, your gear and equipment, your physical assets, and your IP, so that way you keep all of those assets away from salvage, a lawsuit, or a bankruptcy proceeding. And then you have your operational entity is the one that's physically going and making the film. And again, I don't know how to do that. That's where you need to be speaking to attorneys and CPAs on what the best structure is for you. But again, because of these open avenues everywhere else, we think this is one of the most important things you could be doing for yourself right now is splitting those corporate assets and corporate entities up. Your film producer's errors and omission includes defensive IP coverage. One of the big questions we've been getting is how do I attract investors if there is no COVID coverage? One of the ways you can attract an investor is by basically ensuring your intellectual property both defensively and offensively. So if you have somebody who infringes on your rights or accuses you of infringing, you've got an 800-pound gorilla, which is the insurance company on your side. You can afford to litigate to win. The people at your attorneys group who are your chosen litigators basically can have millions of dollars of litigation expenses insured. So that means you guys don't have to back down. You can take it to the mat. The other thing that's cool about some of those insurance policies is you can assign the IP protection to licensees or unbroken protection to new owners. So if you're going to sell your IP or assign your rights to another party, this insurance coverage can actually go with them. So this is my last slide, and then we can pop to questions. So the current actions that we want everybody to take is, first of all, review those cash reserves, because a lot of this is going to be business risk and not insurable. Review the contracts. If it's not insurable, try to get rid of it by contract. And then again, look at these insurance policies. So get real creative about, you know, risk transfer, risk financing, and then in some cases, you may want to put up higher protection limits on insurance policies, maybe excess on top of your workers' compensation, just trying to anticipate a ton of claims coming through there. And then going back to what's being done on the federal level, there is a Pandemic Risk Insurance Act that's being brought forward right now, which would work a lot like the Terrorism Act. And this is honestly, I think, the best way forward that we all need to be pushing for right now. It would work by the consumers paying a tiny little bit of premium on their own insurance policy. The insurance companies would be paying maybe 5 to 7% of all of their written premiums into a fund. And then they will offer insurance coverage for pandemic, cast and crew, business interruption, everything else we've been talking about up to a certain limit. And anything past that limit then gets turned into the federal government, who's going to have this ginormous fund. So again, works just like the Terrorism Act. So we are asking people to please reach out to your representatives and try to get this pushed through. I have a lot of details on where this is in the process, so you guys can email me on that. And then more importantly, shop early for your insurance.
Mm-hmm. Maybe we can also get a little write-up from you that will help people in that messaging.
That would be awesome. And then, yeah, everything's volatile right now. So again, reach out to your attorneys and your financing partners and your insurance people early. And that's going to help everybody a lot. So hopefully, and with all that in place, we can get back to work and do so safely. And, you know, again, try to do everything we can to stabilize the insurance and the legal marketplace so we can all get on with our day. And that's it.
Thank you, Justine. Virtual quiet round of applause. Okay.
You guys.
Let's see, we do have a few more questions and a little bit more time. So back to David Brame up here. Where are the COVID coordinators coming from? Which entities are in charge of training? Where is this pool of personnel coming from? Good question. And actually, see, David was on earlier, the business agent of IATSE 488, and he had to jump off, but he did mention some training available, or that he and some of his folks are working on for producers and production companies, like just general review of the safety protocols. And while it looks like the union will probably have a proprietary training in place for supervisor training, they're also hoping to offer it to non-union productions as well. Tim, I know we all have been in discussion with this. I don't know if you have anything to add on that in C. David's absence. And I don't know if he would say the union is the training entity or if it would be offered through OMPA. I think we still have some details to work out, but anything I'm missing there, Tim?
No, just that what the training specifically is and what people need to be this COVID supervisor has not yet been publicized or solidified yet. So the idea is that it's probably gonna draft off the OSHA 10 and the OSHA 30 protocols. So we're exploring that in the short term, but it is going to be an issue for everybody that the specific training has not been defined and who's providing that specific training has not been defined. But as soon as it becomes available, we want to make sure that everybody here knows about it, but also that it's available to everybody. So we're working on that too.
Lisa?
Yes.
So there's several companies that have that are also popping up that are training production companies in COVID procedures. I think our office has a list of 2 or 3 of them. We can make sure Chris has it and he can send them around. It's very much like the companies that would otherwise do sexual harassment training. And then they can also recommend individuals who, or provide individuals who work through their company to be set supervisors and things like that. At least bigger productions have started to use them. I don't know if that necessarily applies, but there are companies that have actually started to come up with and develop, you know, sort of elaborate COVID training policies for productions to teach them how to do it. And just as there would be a sexual harassment training, there will now be a COVID training through some of these companies.
One question on that, Bob. Thank you. Does the IA approve those people as being supervisors on union jobs? Do you know if it's something that they've approved or not?
The specific, it depends. So several of these companies are companies that have provided high-level security and other similar services for studios and are generally approved. They are currently being looked at to be specifically approved for COVID, but because they have been approved and have been working realistically with production companies on sets for, you know, many years, it's expected that they will be, but it's, you know, this is all still too early. They're just starting to come up, but everyone has sort of approved the concept of having at least the training, if not the individual. You know, everyone's supportive of a group that can sit down and talk to the entire staff and give them a training as like a sexual harassment training. And but I don't know about, you know, if their individual on-person set people have started to been vetted or approved yet.
And then Joel, you made a comment, maybe you could share some of that information around the certifications you've taken, because until there is, that kind of set of standards and training available, people are still doing production, right? So there needs to be at least some level of training, even if it's not what it will be official, you know, down the road. What was the other question I saw in here? What are your instincts about how much of this will change upon the release of a viable vaccine? Justine or the DWT team?
Well, I was about to say the vaccine will make it easier, but we know that vaccines aren't infallible. You know, my personal feeling is, you know, the insurance pricing outside of where those main areas are getting hit, that's not going to change at all. But the more things that happen where we bring more certainty to what's happening, and the vaccine could then, you know, slow down transmission. And again, people wouldn't submit, you know, you tell us what our protocols are. Each one of those things brings the risk down. And then the more they see the risk coming down, then the more availability. So cast and crew limits might come back, or they might get higher. You know, more states might feel less bad about this employer's liability question. Work comp might feel better about really being more proactive on presumptions of coverage. So the vaccine would definitely make a huge difference in reducing risk, but even then it's never going to eliminate the risk. But, you know, again, it would make things a lot better. But we don't know how long that's going to take, so we have to do these other things that we can to reduce risk in the meantime.
And I see one more question in here. I think someone just added another one, but backing up a little bit, maybe we'll take these last two questions. With so little video work coming right now, should small production companies consider a la carte insurance instead of policy renewals?
Oh, that's a great question. It's going to be a classic. It depends. So most of the short-term policies for general liability run $450 to $500, and it doesn't matter whether it's for a day or for 60 days. Gear and equipment insurance on those a la carte short-term policies can be $250 to $350. I have carriers that'll write an annual equipment policy for $270. So doing a la carte on your own equipment, like particularly if you have small amounts of owned equipment and maybe you're only going to rent $75,000 to $100,000 worth of gear, it's a whole lot easier to insure your gear all year on a small policy rather than doing that a la carte. But then the liability side is going to kind of depend on, are you doing 2 or 3 of them? If you're doing about 3 of them, it's going to be cheaper to be on annual. And then there's some protections that aren't available at all on the short-term policies. So you can still get cast and crew coverage if it's available on a short term, but you'll never get the business interruption, loss of income type coverages, the imminent peril. So those things are only available on annual policies, not on these short-term ones. So really what your mix of business looks like over the year, if you're going to be mostly commercial because now you're out doing a feature, you know, maybe we can scoot you over into a completely different type of insurance company because you're not running large crews anymore. So I'm rewriting a lot of my people who normally would be doing features and documentaries plus commercial work into different insurance companies because they're now no longer doing the higher hazard large crew stuff that they were. And so we're shifting them, you know, from one annual policy to a different one, or in some cases we're insuring just the gear and waiting until the next production hits to do the liability piece. So there's parts of that that I don't like because you're still out developing things and advertising. I don't like people going bare, but I also understand, you know, if you're not eating, you got a choice to make. So that's kind of what we're doing on our side.
And very last question, and then we'll call it a wrap. This is a future forward question. I like we've got some planners on the call here. If a vaccine is released, when a vaccine is released, can an employer require proof that a prospective employee received the vaccine?
So generally, no, you can't for a prospective employee ask medical questions before you make that conditional offer of employment or hire them. But when we get to this point that there is a vaccine, I suspect we will see more guidance issued by the EEOC. That's the federal agency that is in charge of the disability law. I expect we'll see more guidance from CDC. So I think we're gonna have to wait and see, since even the current guidance changes every week or so. So I think we'll have to see. But generally, the answer I think will be no, not before hiring.
And I would say from things we've seen, you cannot require someone to have a vaccine, particularly if they're already an employee, because they may have certain health situations where actually getting a vaccine puts them at higher risk because of other either biological, chemical things or other factors. So for instance, there are people with hyperautoimmune diseases, or they might have an allergy to a specific component in the vaccine where that would actually be more damaging to them. And then you would then get sued for forcing them to have the vaccine. So again, there still would have to be a mechanism where they can opt out. And then that's going to get back to Christie as far as how that works.
Well, with that, we are at time. So I just want to say a huge thank you to the experts on this call for sharing this time and your expertise with us. A lot of claps and thumbs up. What's that?
Thanks for having us.
Yeah.
Absolutely.
Sounds like we might want to do another one at some point, because obviously there are a lot of unknowns and we'll be learning as we go. So maybe we'll do that down the road, and that will be my shout out to this community. Let us know what it is that you need. That's how we end up developing our program, is based on the community's needs. So always feel free to reach out. Without further ado, I will let you get on with the rest of your days, and thank you very much.
Yep. And I can email people the full presentation, and y'all can call or email with any questions you have. I'm always happy to delve into particulars.
Yep, and I'll share out the recording as well. Okay, thank you all.
Bye, everyone. Thank you.